All right, I'm from movie be akwaba from rare 2 Kenny and Blossom YouTube so I say ebusia ba nsem ahodo a question and advice na ifo nyina me say no info bi aba betodwa ado abusia nsem anu odin pen we dia anu odene e be kwani akwa akogin nsem yanchim Mr. Sanson na ubu ene ni dey kwanse so unya subscribe from my YouTube channel ya na no sabo subscribe button so we are now the bell notification icon so atwa se be next time bia no a doppy video our channel so answer can be n10 so
it's not the video conference where I'm answering specifically, but the meaning of it. The meaning of it is that he wants to talk whilst he's still in the US, right? Before he comes to Ghana. And I say we should take it because the advantage is that, and there are ways to allow us to take it. You apply to the US government, blah, blah, blah. We have the Mutual Legal Assistance Act. We've referred to it in the previous weeks. The advantage is that if we reach out to him there, communicate, and then we take the 2 statements from him, that's the caution statement, charge statement, possibly, etc. If it doesn't come after the recovery, then we have the opportunity to now start a trial in absentia. If we contact him, he does all those things, and he doesn't come, then we can start the trial in absentia, meaning that we will start the trial whilst he's still in the US, whether he wants to come or not. So that is where my pain is, that when he first made those overtures, that offer, the OSP didn't take it. We should have had a plan B. Nothing stopped us from taking a plan B. It's wiser. It's like the Bible. You know the maidens who went to the wedding. The wise ones took what? Extra oil. Then the foolish ones just went with their lanterns like that, with that extra oil.
Preach
so,
on, brother.
Preach on. You see, so we should have taken the plan B because we could have taken those. And so when he refused to come on the June 2nd, we could then have gone on with processes to start the trial in absentia.
Well, but
because
you here, I think that Samdanko was very clear in his words why the special prosecutor does not think the way you're thinking. Because he says you don't know why they need him in person. That's number 1. 2, it is not just the OSP that needs him to investigate. Now we know that it is the National Intelligence Bureau, IOCO, and then OSP all need Ken Ofori Atta to answer questions.
Simple. Let me answer that. And that day.
So really, it's not a position he's in tandem with.
Number 1, that same day we made it clear that look. The OSP is using state resources. So at every point, we are also holding the OSP accountable. As a lawyer, I also understand the processes. Okay. I don't know what they need him for, but at least a little that I know is sufficient to make an informed decision here. In law, you see, when you are going into a trial, the criminal trial, there are some 2 basic prerequisites you need by our practice to enter the court. Sometimes when you don't even meet those prerequisites, you're able to enter court. Number 1, there's what we call the caution statement, right? Caution statement. So lawyer Mam is here. Usually, that's the one that so caution from the word like warning. So the state agency investigating will warn you, will inform you why they want to take a statement from you. And usually it's done after an arrest. And let's be clear, when we say we are arresting somebody, it doesn't mean you take the person, put the person in cell 1 day, 2 days, ad nauseum. No. Arrest simply means that you touch the person, right? Inform him why you want to confine him. That, okay, lawyer man, touch wood, lawyer man, I'm arresting you for the offense of private gain, okay? Using public office, okay? Just paraphrasing. Anything you say will be taken down, blah, 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 right? So we do the caution. Then after those warnings, he will write his response. So that is that exercise we are saying that can be done in the US on our behalf by the US officials. Okay. Or OSP can go there and take that statement. So you see why when he said he wants to do video, we said the meaning of it is that he wants to talk with us in the US. So what technically OSP first came out to say is that no, you can't start with video conferencing when you've not done this exercise I've referred to. And I said the meaning is that then go there. After all, OSP went to the UK when it came to the Foster Adam Mahama case. They went to the UK and did that exercise, etc. So in this case, we could have gone. Or if we don't have enough resources to go, we'll ask the US government to help us. And they would have done it for us. So after the caution statement, there's also another statement called charge statement. So this time, you are telling the person that, listen, well, it doesn't matter the answer you gave me in the caution statement. There is also, I'm going ahead to charge you. So you see that we don't charge the person in court. Usually we charge the person in the offices of the law enforcement agency, whether it's police, UYOKO, OSP. So the charging is done in their office. So you then go ahead, well, I'm charging you for this and this and this offense. What's your response? And remember, Ofori Atta is not bound to give OSP any help. Ofori Atta can then just say, no comment. No comment. And that's it. And then sign. So the main thing we should realize is that the burden is on the OSP to prove the case. So even if you need him for further interrogation, please, let's repeat. Further interrogation is not a prerequisite to enter court.
I see.
Ofori Atta doesn't have any obligation to incriminate himself, to give you the information. No. If he feels remorseful and he wants to spill the beans, you are only lucky. So that is why I'm saying that the other things OSP needs him for, I don't know. But these two things I've said, these two statements, when you have them, you can enter court. Please, with the caution statement and the charge statement, you can enter court. And let me even further repeat. There are some occasions that the accused doesn't want to even write the no comment. Please, when the accused says he will not even write the no comment, you can still enter court. Please, let's be clear.
Okay.
There is no part of our constitution, the criminal procedure, that mandate. If he says, I will not write, you can't force him. So are you saying that because the person says, I will not write, then you can never enter court? Is that the law? So even the two statements, the accused can say, I won't write. And I'll show you a practical example we're involved in. When the coup plotters case came, the ACP Agojo and Mark Palm, on one occasion, you see that when the Attorney General saw that they would lose the case if they did the jury trial, then they decided to change the offenses. Because if you're doing the treason felony in the Act 30, you needed to use a jury. When they saw the selection of the jury, etc., from experience, from the way the jurors, you know, let me be very plain. You can hazard a guess. From the names of jurors, etc., and a little of demeanor, you can hazard a guess that these people will not return a conviction, even though they've not heard. Please, I'm saying from experience. Look, human beings, we don't use just only the scientific things we've learned in the books. We also use gut feeling, etc. So from experience, you can see some names, etc., that this name is not likely to convict, etc. So Godfrey Dami rightly guessed it, that he won't get, he's not likely, the word is likely, he was not likely to get a conviction. So he changed from treason felony and now came under Article 3 for high treason. And so under the Constitution, if you're using Article 3, the high treason, you didn't need a jury. You now needed 3 judges. So Godfrey Dami guessed that with 3 judges, his chances of conviction were higher than a jury of 7. You see, because, you know, by then, the story was that, this is a kitchen knife coup, and Ghanaians were hungry and didn't think that's an important case, etc. So Dami stopped and then went for high treason. The PIF, all of that is not the important part, but I'll just give you the background. Okay. But my main point is that, so when he changed it and they invited us back to the NIB, okay, previously BNI, our clients refused to write. We refused. We told them we are not writing any statements.
I see.
And then the case was taken to court. Justice Efia Sewa, Asariboche, Amaliboba, and then Justice Stephen Opon, they sat on the case. So Agojo and Co, we told them we are not writing. And you think when we said we are not writing anything, even no comment, we didn't write even no comment. Did the case stall at the NIB? The next day we were in court. It was a Saturday, yes, thanks to the Kwebu number 4 versus Attorney General number 4. We were in court. It was a Friday afternoon because we asked for bail. They wouldn't grant us bail. So we went through the Chief Justice, Eni Yebua, and based on Kwebu number 4, he ordered that, okay, the judge should sit on a Saturday. And so we went to court on a Saturday. Well, of course, we got the bail on paper, but they couldn't come out that day. So my point is that the main point out of the whole story, just one sentence, the accused persons refused to write. the caution statement, Charles, we said no comment. I mean, not even no comment. We didn't write. And the case was in court the next day. So the point we are making is that I cannot second guess the OSP, what OSP needs Ofori Atta for. I can't. All I'm saying is that as a practitioner, I also understand the law enough to know that this, even if those two statements, the accused doesn't write them, you can still enter court. So if you need him for some other purposes and he's not coming, you try and meet the two basic ones that usually it's expected that you try to elicit those. Caution statement, charge statement. If he answers those, fine. If he doesn't answer, because you demonstrate to the court the efforts you made to get those statements and he didn't answer, the court will go on. So please, it's not answer to say, do you know what we need him for? No. It's no answer.
I'm re-echoing what...
Yes, and that day...
We were here.
The OSP himself has told him why he very clear. But I'll make that
point. So now let's go to the next point. But this one, we are just explaining the background. So I'm just saying that we should take the plan B whilst it's still there. But also to be clear, this second time the OSP is put him on the wanted list. And that's the substance of Ms. Okanse's question. I'm in support of the OSP declaring him wanted this second time. Remember that the first one, I was not in support because, as I stated, when he was traveling, he informed both the previous and current chiefs of staff. All right, so that's why I didn't support the first time. But this one, I support it. So now, the question, Mr. Okanse, your question was that, has the wife's interview made the case better? And I said...
now we have some detail that it will take at least 3 months for him
to for now, yes, that's her case. But based on Ofori Atta's previous conduct, I can't trust him. So I can't use that. I can't believe it, but I'll use it in the analysis. Now, so with what OSP is doing the plan B. The plan B, because the plan A is Ofori Atta's second offer that, well, after 3 months, I'll be strong enough to come. Right? But based on the way he swerved OSP on 2nd June, OSP can't trust him. So the best thing is to initiate steps to extradite him. So you can't fault the OSP for initiating the steps. No, you can't. Because Ofori Atta swerved him on 2nd. Now let's answer a bit of the wife and then show why Ofori Atta's conduct has brought him where he is now. The wife says that, look, as I said, her interview made the case slightly worse because out of her interview, this is something she said. She said before the March 20th and 21st biopsy, which is diagnostic surgery, they had always known, please, with emphasis, let's get this point. They had always known that if the biopsy